once again, thanks everyone for being here. We're going to start off talking about the last legislative session a little bit. Gentleman Steve Aleman from Disability Rights Texas is going to start off talking about himself. You met Edgar a few minutes ago. He's going to do the same. And we'll probably spend about the next 45 minutes or so on that and adjust our program accordingly as we go forward. Okay, everybody? Ready to go?
Thank you very much. Let me get the camera set up and I'm sharing this stuff.
Well, we appreciate all the hard work at Disability Rights Texas. DRTX is one of those pillars within the state capitol, right? I've had the privilege of being able to work with Stephen already for what, 2 to 3 sessions already, and there's a couple of bills we've worked on together, and so Stephen for sure is a wealth of knowledge and information within the building. And one of the things that I always think is always good is institutional knowledge, right? And Stephen has been in that building for I don't know, for as long as anyone can remember, really. I'm not gonna say he was born in the building, but you know, he's close to that, right? But I appreciate it. And just to start,
Juliana's got control of your slide. Right?
Okay, appreciate it. Thank you. Thank you. And just real quick, right? Just so you can get a context of what the legislative session actually looks like. We have here in Texas, we have a 140-day legislative session that meets every 2 years. So we're not like DC that meets, every week or every month, right? Our legislative session begins in January, typically ends somewhere between May or June, right? And then from there, whatever doesn't get passed out of that has to wait until the next legislative session comes. So if there's an election, let's say in 2026, that's upcoming, the legislative session in 2027 will begin, and then so on and so forth. So that's kind of how bills are getting passed, and that's why you have a biennial budget here in the state of Texas. And again, for context, we see on average, or this time around, we saw somewhere between 8,000 to 9,000 bills filed in the session. I'll repeat that again. Approximately 8,000 to 9,000 bills were filed this session. How many do you think percentage-wise got passed during that time? And anyone again?
100.
Well, a little bit more than 100, but percentage-wise, close to 14. I believe it was 15% that got passed. 10 to 15% of bills got passed this session, which I believe were around 1,200 bills this time around. So when we talk about these bills, when we talk about the, not just the priority bills, right, which are SB 1, 2, 3, 4, etc., but when we talk about Senate Bill 568, right, and a couple of others that Steve is going to talk about, it is very, very important because not only do you go through, just filing the bill, you go through the entire process of getting it on the House floor, then you go back to the Senate, right, and it's a process. Then if there's differences, then it goes back to conference committee, and there's a lot of horse trading back and forth. So that is, and that's a presentation we can come back to next time around. But let's talk about Senate Bill 2 today. Now, what is Senate Bill 2? You've heard, as I mentioned previously, the terminology, school vouchers, school choice, right? And in essence, what the principle of it is, right, is that the government, quote unquote, wants to give parents more control over their child's education, which in essence, I think we could all agree with that, right? We could all agree that parents have a right to choose their children's education. However, when we're talking about school vouchers or school choice, it's a little bit more complicated than that. And in Texas, what we ended up doing, because there's a different forms of school choice, school voucher, but what we ended up doing here in Texas is an education savings account program. So what this means pretty much is you have a state agency that will control a bank account for each student, and that student will receive X amount of money within that bank account on a quarterly basis as prescribed in state law, right? Well, we see it a little bit more, semester, monies, but typically there will be a quarterly deposit into that student's educational savings account, and that will provide funding for approved education-related expenses. And we'll get to that here in a second, right? But because this is a startup program here in the state of Texas, we are not seeing an extended amount of slots available for students. So not every student in the state will have the opportunity to receive or be approved for an educational savings account. In fact, there's only 100,000 slots for students to access ESA program, which I believe in total, when they were looking at the statistics, I believe it was approximately 1 to 1.2% of all Texas students that will be that these ESAs will be available for. And now, while the bills comes into effect September 1st, 2025, kind of similar to what Steve was mentioning with some of the other bills, this will start with rulemaking. So we will not see immediately the ESA program come into effect for the next school year, but it will come into effect, or it will begin in 2026 and 2027. Let's go to the next slide, please. Now, in Texas, we have, I believe, approximately $73 billion for public education funding. And that doesn't include the $8.5 billion that was just approved for additional public education funds. But the ESA program ended up costing approximately, just for the 2026-2027 biennium, it will be $1 billion, and that will be capped. So not only will this provide money for the students on for the semesters or for the school year, but it'll also provide for administrative expenses. It'll also provide for helping certify some of what we're going to call the educational assistance organizations that we'll feature in a little bit as well. Future funding will be determined by legislative appropriation. So we do not have a set number as to how much money will be allocated for that program until we come back through the budgetary process. And so this time around, the $1 billion was set aside already in the state budget when the original draft came out. One of the amendments that was attached to the bill, I believe it was on the House side, was to cap the number of the dollar amount to this program. The comptroller, which this is a very key difference compared to public education. TEA will not control the ESA program. It will be the comptroller of public accounts that will have sole discretion over this particular program. They will administer the program fund. The comptroller will be the one who will be certifying the educational assistance organization. They will be managing every single account for all of those 100,000 students that will be available. And they will also be able to fund the program through state transfer, interest on the actual fund, donations, grants, etc. So we don't know how exactly the process is going to look like just yet on that, because the rules have not been made yet. But it's for anyone who the policy wants in the area, this is going to be a very, very crucial step. There will be public hearings. There will be soliciting public input. So if you're interested in recommending a certain procedure or recommending certain things to be added, to the rules, please be aware that this will take place within the next couple of months, and it's free to everyone to participate. I encourage everyone to go online, look at the Texas Register, and see when these official rulemaking procedures will come out so you can participate. Next slide, please. Now, eligibility requirements. On top of the 100,000 students, right, that will be eligible to, or that will be available for these slots, there are eligibility requirements. First and foremost, you have to be a U.S. citizen, a permanent legal resident, or lawfully admitted child. So, if you are, in other words, have some form of legal status, right, you will be able to access it, but you will not be able to access it if you are an undocumented immigrant. So this is something very important when we as advocates are presenting the program. We have to be clear and transparent with our clients that not everyone is going to be able to qualify for this program, particularly in the Hispanic community, where we deal with a lot of Spanish-speaking parents, right, that may have just arrived to this country. Depending on their method of arrival, the way they came in, they will not be able to access this program for their child, regardless if you have a disability or not. Secondly, they have to be eligible for public school enrollment or a pre-K program. In other words, if they are eligible to go into a public school, you're eligible to receive funding, or eligible to apply and be considered for this program and for one of the slots. Participation ends upon high school graduation or re-enrollment in a public school, or, I forgot to add that in there, or if the comptroller decides to terminate your account on the basis of fraud, waste, and abuse, or you're not following the procedures and guidelines, that are established through that. There will be an appeals process that will come out of the rulemaking from the comptroller, but we don't know what that's gonna look like yet. All the statute says is if there is an appeal, the comptroller's decision is final. So you will not be able to get your account reinstated if the comptroller determines that you are ineligible and thus you're not gonna be eligible to receive those again. Another interesting part to that's not on the presentation, if you're able to, if you are approved for educational related expenses, but you utilize that money without it being an education related expense, your account can get terminated. You will be subject to disciplinary procedures as well. So again, when we're informing parents, we have to be clear about what these requirements look like. And again, pay attention to the rules because the rules will provide a lot more insight as to what will be allowed, what won't be allowed, okay? And of course, there is gonna be a tier-based system when we're talking about who gets to be part of that program. Because there's only 100,000 slots available, because there's only 100,000 slots available, they're gonna be priority level. And so there is, in state law, by the time they reach 80,000 students, a lottery system will start to kick in. And so those students will, you'll be able to, kick it in. But prioritization for these students will be siblings, siblings of a child who is in that program, children with disabilities, and low income applicants. There will be a handout that Robin, I believe, will send out to each one of you. That's the research analysis that the House Research Organization compiled for the bill. And in that analysis, you will see what those tiers look like. But there are certain levels, through the poverty level that you'll be able to see who qualifies based on certain levels like that. Next slide. Now, the funding amount. This is where it gets a little bit interesting. Because in Texas, while we do have the average daily attendance, right? I believe the last time, a student can correct me if I'm wrong, I believe funding per student in Texas was $6,500 approximately. You did get a very minimal increase to the basic allotment of $53 per student. But with that being said, right, we know that private schools charge way more than $10,000 a year. And so if you are considering, if your clients are considering sending their kids to private school, utilizing these educational savings account, and if it is tuition above $10,000 a year, they will be responsible for covering the rest of that tuition. Let me say that again. They will be responsible for covering that part of tuition. You will only get $10,000 a year or quarterly, approximately $2,500, right? And that will be sent, let's say, directly to the school. But anything else that is not covered, that's still your responsibility. So that's approximately 85% of public funding. But for students with disabilities, there is a higher number there because students with disabilities do require, many more services, right? They may get up to $30,000 a year for students with disabilities. And this is meant to incorporate some of the additional changes that were made to the state funding formulas for special education, right? Some of the tier-based formula that will come into play here within the next couple of years. So you're eligible for that. Now, if you're a homeschooled student, regardless if you have or don't have a student with a disability, you can only get $2,000 a year, and that's it. And those $2,000, so the $10K, the $30K, and the $2,000, you will be able to utilize that in any way that you want, as long as it's an approved educational related expenditure. Now, another part that we don't have within this presentation, right, for the sake of time, another noteworthy part is that there will be a vendor system within the comptroller's purview. And so anyone who wants to get approved or certified to provide services through the ESA account will have to go through a rigorous verification and approval process that will go through the comptroller's office. Again, we don't know exactly what it looks like just yet entirely, but what we do know is that there are pretty much similar regulation with, when it comes to blood relations, consanguinity, and a couple of other different requirements, right? But you will be able to spend any of these amounts of money to any vendor as long as they're approved by the comptroller. Now, some of the vendors that have been used for the supplemental special education grant, the SSCS grant, maybe some of the parents here have been able to obtain and utilize that grant, and you've been able to utilize it through some of the vendors that were provided, right, through TEA. You'll be able to use that as well for the ESA. That, they will be able to kind of transfer over to the comptroller's system. Okay, so that's kind of there. So next one, please. Now, Certified Educational Assistance Organization, the EAOs, these will be the organizations that will be in charge of helping the comptroller administer the program. They will be the ones receiving the application. They will be the ones providing, matching you with providers and vendors. They will be the ones making the payments, right? They will be marketing this ESA program, and they will be the ones that will be maintaining your educational records. So you won't go directly to the comptroller to get your educational records that are, fall under FERPA. You will have to go through these educational assistance organizations. We don't know who these organizations are yet, so just keep in mind that they will be coming up. They will be certified here within the next couple of months before the start of not this school year, but the following school year. Next slide. These are some of the approved education expenses. If you want to take a picture of that, private school tuition and fees, textbooks, instructional materials and uniforms, educational services, tutoring, therapy, transportation, and even technology purchases. But that will be limited or capped to 10% of the funds. So let's say you get $10,000, you'll only be able to use $1,000 for technology purposes for that. Next slide, please. Again, program rules will go back. Other program rules will have to be adopted by May 15, 2026. And it will begin 2026, 2027. We'll take a couple of questions at this time.
Actually, I can wait on the questions here.
Okay.
Take a, after a ceremony prerogative. If Steve comes back.
Okay.
Then we'll give questions for everybody.
Okay, perfect. Okay, sounds good.
That's all.
Okay.
Well, we transition back to my PowerPoint. I just want to make one observation about the ESA program, that, as Edgar noted, a student with a disability will be eligible for a larger bank account, if you will, because they are a student with a disability. That's only if you're special education, not 504, just to be clear. And secondly, that does not obligate the private school that you enroll in to provide special education services. Their legal obligations continue to remain under principally the Americans with Disabilities Act, Title III, as a place of public accommodation. Perhaps Section 504 if they, by chance, take federal money in some form or fashion, although seemingly unlikely. So your legal recourse to is only ADA Title III. So that's really between the family and the private school to make the most out of that, up to $30,000. So again, but we'll move on in the interest of time. Back to my presentation. Then we'll come back to questions. And I know that's the best part of being here and being online is getting access to a Q&A session. So we'll try to get back to my presentation. Again, I had in my 70 slides covering 20 bills. I only got through 2, HB2 and SB 568. And then Edgar did SB2. I'm not going to talk about in the interest of time all the rest of them. I'm going to try to pick and choose a couple of key ones. I think that are going to be most important. I don't know if you can skip.
Right. Yeah,
Will we have access to your slides so we can go back and review your bullet
That's
points and the bill
yeah.
at our leisure?
So I'm happy to make the slides available. I did email them to Marty and Robin,
Cool.
so they'll get them out to you all. And I apologize that we weren't able to circulate that in advance. But
also, in the interest of time, if I might have missed it, you focus on behavioral issues as well.
where I'm going next, thank you. Perfect. Yes, right there. We can tap on that and just go to it. How about that? House Bill 6.
Hold on.
So,
Let me get-
oops, so
let me shift
as
that.
this comes up, just to be clear, obviously this session was an education session, if you will, for better or for worse. So many major bills were passed. As you can tell, we're talking about a lot of very low number bills.
Forward and backward.
Perfect, thank you. So we just talked about HB2, SB2, and here's HB6. So HB6 was the flagship school discipline bill. You could just spend an afternoon talking about HB6 alone and HB 121 to come up, but I'm going to try to just hit super big highlights. One of the biggest highlights is an emphasis on teachers. Need some feedback now. Emphasis on teachers being able to remove a student from their classroom. Now, this used to be the law, just to be clear. This was in Chapter 37, our discipline code provisions, but it's been enhanced. Now, the key aspects of removal are about interfering with teaching, instances of unruly, disruptive, and abusive behavior, and bullying. The key things for us, for you to take away, is one, know that in addition to what was the existing notice requirements by the campus behavior coordinator, now for these teacher removals, there's optional modes of being notified by either the teacher or an administrator to tell the parent, hey, we removed your child. One of the new aspects of this process for teacher classroom removals is a conference with the parent within 3 days. 3 class days of that removal, there has to be a conference. And that is codified now in Chapter 37.002C for you to take a look at the details about the procedures for that conference. The point of that conference is to basically decide, well, where's the student going to go? Because a teacher is now, in essence, empowered to say, I don't want that student back in my classroom. That's going to get kind of tricky for a student with a disability, potentially, especially in maybe smaller school districts, smaller campuses. There are some options, however. One aspect of the bill, also in 37.002, is this new requirement for return to class plans. Unless the teacher signs something that says, I'm willing to take Stephen back. He's been a troublemaker. Look, he showed up class for, chronically absent, late. Unless the teacher says, I'm going to take Stephen back, the school has to convene a return to class plan, and that return to class plan can override that teacher's refusal to take Stephen if you can get everyone else on board. So as advocates, to the extent that you are at campus, we had a question earlier about going to ARD meetings, make sure or your clients, your parents are aware of these conferences, these new return to class plan requirements. And to the extent that you are going to be an advocate, think about like how are we going to get Stephen back to an appropriate placement, particularly if the teacher is saying no. Now, I want to point out one last thing here is that TEA is supposed to develop a model template or form for the return to class plans. It's not clear when that's going to happen. So as we get to this new school year, it could be a little bit of a free-for-all about, well, what does a return to class plan even mean? Because as far as I know, we've never had that statutorily across the state. So until we get TEA guidance, it's going to be really on the shoulders of parents and advocates to think about, well, what's appropriate in terms of, maybe classroom modifications. Maybe we need to get an FBA about behavior and understanding, well, what's prompting this behavior. So bottom line here about HB6 and the emphasis on school discipline is a lot more options for teachers to kick a kid out. But there are some procedural hoops about the conference and the return to class plan that you'll be needing to be aware of. And again, I would dig into 37.02 and in particular 37.02 subsection C as in cat. Another key thing, let's see if I can move this, is about in-school suspensions and out-of-school suspensions. The law has been changed in-school suspensions can now be unlimited. However, a removal to in-school suspension has to be reviewed at least every 10 school days if the child is going to be put into in-school suspension or ISS. Now, let me be clear. We still have federal rules, federal law about discipline of students with disabilities. What I'm reviewing are changes to Chapter 37 that apply at large, but can also be used or attempted to be used against a student with a disability. That's where you come in as an advocate or attorney or knowledgeable parent and say, wait a minute, I know that schools could do a lot more to quote punish or discipline kids, but you have to be mindful this all has to also interact and be compliant with IDEA. But just to let you know what the general process is going to be like now going forward is that in-school suspensions, there's no limit. We can say Stephen's going to in-school suspension for the rest of this school year or whatever. But if they do that every 10 days, in theory, someone on campus, an administrator needs to look into that and say, is this really working for Stephen or not in theory? So you want to be asking, well, what kind of documentation? What were the criteria for you to do that review, right? And think about getting those notes or making sure that parents are asking for those notes for you. Now, there's, I've got a couple questions here.
Why don't you finish up?
Okay.
And then even though we're all know we're running behind, but let's spend about 10 minutes on questions. Yeah.
Okay, so just another key thing about discipline and art committees, again, where you come in as an advocate or a knowledgeable parent, is if it's an instance of bullying, harassment, or specifically a hit list, a student cannot be removed that would be a change of placement unless there's an art committee meeting. This is sort of a manifestation determination plus, if you will, review when it comes to these specific instances of bullying, harassment, and creation. This is in effect an MD review on state law now for these particular removals that would be a change of placement under these circumstances, and that's codified now in 37.001 B-1, subsection B-1. So bottom line is that discipline is going to get a lot rougher in general, probably a lot rougher for kids with disabilities. There's going to be a lot more teachers are going to quote empowered to get rid of disruptive kids. The theory is we're letting everyone else learn by getting rid of the troublemakers like Stephen. But again, be mindful that they still have to follow special ed law, IDEA, despite all these enhancements in state law and some of these little nuances like extra conferences, extra plans, extra MD reviews in effect. Again, that's the quick and dirty on discipline itself. Now, when it comes to threat assessments, another new dimension of discipline, if you will, I want to emphasize something that we're, at least to the extent that we were able to get any legislative achievements, this was another one where I'll tout Disability Rights Texas. We were able to add language when it comes to threat assessment team meetings and students with disabilities. Now, if a student with a disability is sent to a threat assessment process, someone on that threat assessment team has to know the student and know about their special education needs and be one of these four individuals, either a special education teacher, a behavioral analyst, a clinical or master social worker, or a LSSP, or now school psychologist. One of these four people need to be at the table on the threat assessment team if it's a student with a disability. And this is new law now as part of House Bill 121. Now, I want to make an important distinction here because unfortunately, you might get this pushback. This provision was also included in House Bill 6, but in a slightly different manner. And unfortunately, in House Bill 6, it just says the extra member of the threat assessment team for a kid with a disability just has to know something about special education, not about the special education student. They left out the word student mistakenly. So thankfully, at least on this front, TEA has already come to our rescue. And July 17th, just 2 weeks ago, a week and a half ago, TEA sent a letter to school districts that effectively said, when it comes to threat assessment teams and students with disabilities, HB 121 trumps HB 6. The threat assessment team has to have someone who knows specifically Stephen, just isn't a special ed teacher randomly picked because they happen to be the available special ed teacher on Thursday afternoon for this threat assessment meeting. Okay, so be aware of the letter. It went in, if you get the PowerPoint, I have a link, as you may tell, there's blue highlights in my presentation where you can see it. It's also, of course, posted on the TEA website. But just know when it comes to discipline, and particularly the new dimension of threat assessments, that there is hopefully now a stronger provision of the theory is they'll understand, why did Stephen do this? Maybe it was a manifestation of autism or emotional disability, and so we can maybe not, turn them into the cops or you throw them into DAEP or whatever. Of course, it's no guarantee, but at least this was the best we could get across the line to kind of mitigate harmful removals under the threat assessment process.
Steve, why don't we turn it over to questions for one Edith? I think, but we were talking about it, maybe the one thing that nobody else here can give later or never. So why don't we open up questions for everybody now? So almost as long as it takes.
Okay, so since no, we can do stop, and we're Edgar and I are both right here, so we'll go back to ESAs and discipline right now, just in that domain, and we'll get to other questions later. Sure. Okay. Well, in the center back, please.
Would it be in the best advantage of the student for parents who know their child have behavioral issues to incorporate in their IEP strategic plans of action for the school to take with their child, and then follow up by speaking if they actually follow their plan?
So the question is about parents kind of being proactive and getting provisions into an IEP or a BIP when it comes to behaviors, especially some that might be misinterpreted as threats or bullying, etc. So obviously that's always a great thought. And as we always say, a special ed document. At the very least, put in the art deliberations that I asked or raised that if you can't actually get that to happen. Also be aware, and this isn't a part of the law in terms of the update to the law, but in threat assessments, we were able to, there was another amendment just generally about parents having a role in threat assessment. So whenever there's a threat assessment, schools have to let you know, schools have to ask for your input, and then schools need to give you the threat assessment report. Stephen is a very dangerous, violent kid, lock him up. Now, you don't want to see that, of course, but you'd like to know that's what the school district said about your child, right? So that's already part of the law under threat assessment in Texas. Again, working at the margins and the best that we can do with some of these very punitive approaches. So be mindful, even at the threat assessment level, you have a chance to try to weigh in about not making unfortunate situation worse for your child in terms of consequences. Question here, yes, ma'am. Right, yes.
I just want to know, since you have a 70-page PowerPoint, I'm not on your email list, unfortunately, because I came over from our other one. How can I access these house bills to find out about them and review it?
Okay, so just so TOPA is going to be circulating this. So I think if you just hook up with TOPA, then you'll eventually get this presentation and the DRTX legislative summary. And again, it's 70 slides, 20 bills connected to students with disabilities out of the 89th legislature.
Now, I will add real quick on that. If anyone really just wants to be a policy wonk about stuff like that, There's also a capital.texas.gov. Capital with an O, C, and you have something on it. CAPITOL.texas.gov. And that is your information source for anything Texas legislature. So anything from bills to resolutions, committee reports, meetings, agendas, anything. That is where you have to go. And it will even show you kind of where, where it was in the process. Like, for example, some of the bills that didn't make it out of the legislature this time around, it will show you what was the last action that was completed and goes to show where your bill may have died or, why it didn't make it in the process, there's debate, there's the journal. So that's a really good source of information right there. Yes, Los.
So, are we saying that only special education students are guaranteed the least restrictive environment, the 10-day endless ISS?
So with regard to in-school suspensions, again, the change in law is that there's no time limit anymore like there used to be. But in exchange for that, administrators are charged with looking at the removal every 10 days, 10 school days, whatever I said, it's in the slides. But so this begs the question of for a student with a disability, which is, among other things, what you probably should be doing is asking for a new art committee. And
Students are being denied this restrictive environment.
general education students are obviously not subject to least restricted environment. They are in theory getting access to the general curriculum, the TEKS, despite the removal, but legally that's another, standard separate from students with disabilities.
The size of the ISS one, which it has.
Absolutely not. Absolutely not. No. Okay, Daphne.
Quick question, since a lot of the out of placement, the pattern, of placements is usually, half days, which would count as a full day. If they're, the ISS or change of placements are usually over a few months, like 5 times, 10 times a month, they're having somebody leave early. So how would that work with this new 10-day reviewing?
Okay, so just to be very clear, and again, this gets a little confusing because we use 10 days a lot in special ed law, right? This is a state law 10-day time period. Let's see, a 10 school day time period. There may already have been 10 days accumulated of a pattern that constitute a change of placement under special ed law that you need to be mindful of, making sure your parents are getting documentation to support that assertion so that you can have the federal MD review, if among other things, and or why is it that Stephen's been put into this segregated environment anyway? So there's so many different layers to this, but just from the discipline standpoint, again, don't confuse these state 10 days with 10 days for removal purposes, change of placements. Yeah. There's going to be multiple 10-day timelines running now for a student with a disability under Texas discipline law. Okay, right. So gentleman in the back in the black shirt had his hand up earlier first.
As far as SB2, is there a list of what disabilities take priority when receiving the funds?
No. There's no priorities. As long as the student has an IEP, right? And you can document that IEP, on my understanding, that helps you qualify as a student with a disability. Now, there is a separate component to that as well. Within the supplemental or the funding that they just added for additional special education, what they will be able to do is the school districts will get $1,000 for each new evaluation that they do conduct. And if they find, that the student is eligible to receive special education services, let's say a parent is going to be able to go to the school district and say, I think my child has a disability. They do come out, as eligible with a disability. the parent will be able to take that evaluation, with that eligibility part, they will be able to use that to go to a private school and get potentially those $30,000 for
What
that.
is IEP? I don't know.
The individualized education plan, so the special education plan.
And they have to be part of the special education plan.
Yes, they do have to have an IEP, or be eligible to receive special education services to qualify as a student with a disability.
Somebody
Well-
with, like epilepsy or something like that, does he go to, it's not part of the special.
So the question is like, what is, going back to ESAs, what a student with epilepsy, yeah, so the question is for ESAs, for example, a student with epilepsy, would they be considered a student with a disability, meaning they're eligible for the larger amount in the account? The short answer is probably no, because that student would probably be considered a 504 eligible student. And for the purposes of the state ESA program, it does not make section 504 students eligible for the larger quote bonus for a disability.
But if they are found eligible under IDEA, right, let's say the student has epilepsy, right, and you have special ed plans under an OHI eligibility, right, that will count, right? So again, even let's say migraine diabetes, right, for example, let's say they do qualify for an educational need and through IDEA, they will be able, but only if they qualify through IDEA. Not section 504, to clarify that. Go ahead, yeah.
Oh,
Yes, go ahead.
well, what's the responsibility of the private school if they expel a child with an IEP? Does the money, can you call the money back?
So
Dispersed every quarter, right?
it's dispersed every quarter, and kind of what Steven said, I'll piggyback off of that, right? They have no other requirements to follow, right? Other than the ADA Title III. So kind of let me backtrack. So there is no federal funds that are being used for the ESA program. All of them are the general revenue funds that you collect from state revenue. And so because of that, the protections typically associated with IDEA, right, through the dispute resolution process. So like a due process hearing, like art facilitation or whatever it is, right, that come along with it, they come with responsibilities and certain rights, right? The private school will not be responsible or required to follow those procedures, those guidelines, right? And they pretty much are able to follow along with their own procedures and their own guidelines, right? And I think, and I'll defer to Steven on this a little bit more if he knows more about it, but the way I would, I don't want to say interpret, the way I would see it would be, it would be dependent on the private school and then on the rulemaking procedures that will come out from the comptroller's office.
So then the child let's say a child gets a $30,000
Yes.
fund, and they enroll in the private school, and then 2 months later they're expelled, which is very common, right?
Mhm.
If they can find a private school in the first place. So they get expelled, but the private school is allowed to hold on to the money.
Not to my understanding, Steven, I don't know if you want to
That's
add
the
to that.
question. The question is, what happens to that money? Because it follows the child in, does it follow them out?
And it's the
To
school
be-
that they get kicked out and go back to public school, are they gonna get money? 'Cause
Well,
now
well,
they
so
have
the
to-
short answer is it's to be determined. As Edgar said, there is a lot of nuance that needs to be figured out through controller rulemaking that we will see. Now, obviously, we're all concerned about what you just said, but the law never addressed that. And it's going to fall to any rules about sort of like recovery and allowing the parent to say, whoops, I just lost my whole ESA. And that's it. Okay. So in the interest of time, yeah. Okay, one last question that we're gonna follow up. Yes, sir.
Clarification, AP6. So we've talked about 10-day provision. On that provision for AP6 and the student having an MDR for bullying, harassment, or creation. There's no day requirement in the state law. Is there?
What's the last?
There's no day minimum requirement. You have to be out OSS or ISS for a certain amount of days before.
Correct, yeah. So again, it's an overlay of federal procedures, new state procedures. The state law is silent about when, it comes to these ARD meetings, like how quickly they have to be held. Presumably the district would, want to maybe do it like in a, expedited manner, but there's nothing that says they have to within a certain days.
The 11th day, regardless of it. I don't know why. They still have to abide by the state law first.
Well, the timing would get a little bit tricky. You'd have to think about what is IDEA required, what is this new requirement and 3701 require. I don't want to speculate and say one way or the other, but other than that, yeah, you're gonna have to dig into these rules and statutes very particularly in these situations. But again, I apologize, this is just an introduction, a taste to what changed. And of course, we could be here all weekend digging into all the language, but mostly our objective is just to alert you that then you will do your research in your particular situation or tell your parent, I heard that there's something about this. Now let's go figure it out, or call Stephen or call Edgar or whatever. But again, we're just giving you an introduction, high level review, and appreciate the time that we have with you. And in the interest of time, where are we, Marty?
They were, we're done, I think.
We're already about an hour and a half.
Thanks very much.
All right, everybody.